Engaging legal counsel to create and craft your estate plan is so much more involved than just cutting and pasting documents. I've said it so many times before that I call it Mad Lib's practice of law, and there are attorneys all over the place who are cutting and pasting these same tired documents and reusing them for this out-of-the-box mentality, kind of a one-size-fits-all, but it really fits no one situation. Instead, you want to have an attorney and a team that are going to work together to put together documents that are really personalized to you and your needs and what your goals are. And together, those documents are going to work to accomplish what it is you're trying to set forth. And by having a set of documents that are clearly written, that are accounting for all different situations, you're going to have a much easier probate process. And that's something that you really want to streamline. It's very important. Another misconception that people have is that if they have a will, the will automatically dictate what happens with their assets, when that's not the truth. What happens is having a will is really an invitation to go to probate. It's an invitation to start a lawsuit, because that's really what probate is. Probate is a lawsuit that you're filing. So you have to file that with the court, and little do most people realize that by having a will, it still needs to be approved by a court. And in that process, you need to make sure that all creditors are notified of the process and that the person passed away, and give them an opportunity to extend their hand and attempt to be paid as well. To avoid this process, you would have to avoid the probate process. And that can be done through the use of a trust. Oftentimes, clients come to us and decide or think that they're going to create their own will. And while courts oftentimes understand and want to satisfy the testator's intent, the person who passes away, their intent, there are certain requirements that are necessary in order for a will to be probated and allowed and followed. And oftentimes when people do either your do-it-yourself wills, or they go to an online platform and they cut and paste their will through a series of questions, which are done oftentimes very inexpensively, the result that they hope is not the result that they get. And what happens is, in the long run, you may save money by not hiring a very well-crafted estate planning attorney, and you'll save money by not going through the process, and you'll have what looks and feels like a proper document, but when you start to peel it back and look at it, the courts are going to determine that it doesn't meet the statutory requirements, and that will is going to be set aside, and the court will then resort to intestate succession, the court's rules as to how assets may be distributed. And that might not be what you had in mind. It may not be what the testator's wishes are, and that's going to be a problem. So while you may save money in planning, it's going to cost you a lot more money when you get through the process. Sometimes people come to me with a will that was done through a do-it-yourself means or through online. This is after a person dies, when the heirs come to me and they show me the will, and we realize, oh my God, they're missing some of the requirements. They're missing a witness. They're missing an attestation that's required that says they were of sound mind. They were over 18 years old. Or they're missing the clause that says who the personal representative will be. Now, the personal representative is the person that you designate as your representative to administer or disseminate your assets. And I see this in do-it-yourself wills or online wills, that they forget to include that. And that leaves a lot of question to the court. And by having questions, it creates ambiguity. Ambiguity costs money because it has to be resolved, which makes estates and probate process drag out much longer than they need to. And while that process is dragging out, houses can't be sold, assets can't be sold, money can't be given to heirs, and heirs are laying out money to keep houses going, to making sure houses' pipes don't freeze, and to continue to pay taxes. So an ounce of prevention is worth a pound of cure really stands true in this reason and in this situation. And while there's a larger cost up front, the results are much better and are much more anticipated, and you're gonna get what you want out of the situation by planning ahead and working with a really good estate planning attorney. Call us today.